It's news time. Information is power. Be current. The news headline: why DSS should not be blamed for making Nnamdi Kanu arrive court in the same attire despite court order. The news in full. Recall that during Nnamdi Kanu's trial on Tuesday at the Federal High Court, Abuja, the court ordered the DSS to allow Kanu to have a change of clothes. The court also ordered that he be given maximum comfort while in detention and be allowed free practice of his Jewish faith, including access to his Jewish religion materials. However, Nnamdi Kanu on Wednesday yet again appeared in court with the same attire he wore despite a court order. When the matter was called up, the prosecution told the court that Kanu chose to wear his designer Fendi clothes as they had earlier provided him with new orthopedic mattress, pillows, and also blankets. A lot of people have begun to question the DSS for flouting the order of the court by allowing Kanu wear the same dress to court, but they fail to understand that it was entirely not their fault and they shouldn't be punished for it, since the DSS revealed that they offered Nnamdi Kanu some new orthopedic mattress, pillows, and blankets as requested by the court, and he chose to wear his designer Fendi clothes. Then the DSS should not be punished for allowing him wear the same attire, since it was entirely his choice. Assuming that Kanu insisted on wanting a new dress and the DSS denies him that wish despite the court order, then they can be punished for such. Of his fundamental rights, but defendants raised preliminary objections to the jurisdiction of the state high court to entertain matters pertaining to the federal government. Counsels for the respondents, namely Simon Enoch for the Attorney General of the Federation, Omo Osagi for the police, Amos Story for the army, and Mrs. C. Odukwe for the DSS, argued that the court lacked jurisdiction to hear the matter. Tori specifically faulted Kanu for demanding 5 billion naira compensation from the Chief of Army Staff instead of the Army Council, but the court held that it has jurisdiction to hear the matter. While delivering judgment yesterday in the court, the judge condemned the invasion of Kanu's family house by the military and described this as notorious and brazen. Justice Aya, however, struck out Kanu's prayer to declare his repatriation from Kenya and the continued detention by DSS as illegal. The judge instead suggested to the authorities to explore political alternatives in resolving the issues of his extradition, detention, and trial. Reacting to the judgment, the Nigerian Army says it will study the decision to know the next line of action, and counsel to the Army, Tori, reportedly said that the military would respond appropriately to the court judgment that indicted it for violating the fundamental human rights of Kanu after studying the judgment. At the same time, the IPOB leader in Abuja yesterday asked the Federal High Court Abuja to discharge and acquit him of the 15-count criminal charges which the federal government preferred against him. Kanu had rejected the charges during his arraignment in court yesterday, arguing that they were defective and have no force of law. Besides the alleged effectiveness of the charges, he said that the offences brought against him were committed in the United Kingdom outside the shores of Nigeria and pleaded not guilty to the charges. Shortly after taking his plea, counsel to the federal government, Shuaib Magaji Labaron, told the trial judge, Beta Iyanko, that he was ready to try the defendant. He informed the court that 2 of his witnesses were present to testify in the case and that some exhibits were brought to court to establish terrorism charges against Kanu. Labaron cited Section 396 of the Administration of Criminal Justice Act, ACJA 2015, which stipulated that trial should begin after arraignment, and while objection on any issue could be taken at any time along with the substantive matters. But Kanu's lead counsel, Mike Ozekhome-san, objected to the commencement of the trial, adding that his client had filed 2 motions on notice on the validity of charges and a bail application. Ozekhome said that the 2 motions were fundamental because one of them challenged the competence of the charges and should first be resolved, adding that Kanu desired to be discharged and acquitted without standing trial because the charges were defective. He argued that the second motion, which sought fresh bail for Kanu, was filed on Tuesday, January 18, 2022, served on the prosecution on Wednesday, January 19, and therefore not ripe for hearing. In a ruling, Justice Nyako agreed with Ozekome to first determine the motion challenging the validity of charges and fixed February 16, 2022 for the parties to return to court and adopt their processes for and against the motion at 12 noon. However, Kanu was returned to the Department of State Services DSS detention facility until his request for bail is resolved. He was provided with orthopedic mattress, pillows, and blankets, among others, in compliance with the court order. Meanwhile, Kanu's special counsel, Aloy Ejimako, in a reaction to the judgment of Abia High Court, said that the president should obey the court's decision on exploring political solution and prove that he indeed regards the judiciary, as said in an interview on January 5, 2022. He said, "I am pleased with the judgment, especially as it diminished the vested notion that Nnamdi Kanu jumped bail in 2017. The directive by the judge to the federal government to pursue path of political solution with Kanu is also in good order. Going forward, I see the judgment having significant impacts on Abuja case. I have no doubt that the federal government will implement the judgment. My confidence comes with the recent pronouncement from the president that he will respect whatever the judiciary decides in the matter of Nnamdi Kanu, and now that the court had actually, advised, after awarding 1 billion naira against the Nigerian army and for Nnamdi Kanu, for illegal, unlawful, and unconstitutional infringement of his fundamental rights, to life, dignity, and of his person, and also his personal liberty and fair hearing as guaranteed under the Nigerian Constitution and African Charter on Human and People's Rights. The lawyer of Nnamdi Kanu had actually filed again that the court in Abi State should actually should actually condemn, the expulsion of Nnamdi Kanu from Kenya back to Nigeria by the Nigerian government, and his consequent, detention and prosecution in a suit, marked FHC ABJCR 383/2015, saying that the court should actually, agree that it was illegal, unlawful, and constitutional infringement of his fundamental rights to be expatriated from Kenya back to Nigeria. But then the court actually, apart from awarding 1 billion naira, which was supposed to be 5 billion naira, as filed by the council to Nnamdi Kanu, the judge, which is Justice Aya, however, struck out the prayers, to declare that the repatriation from Kenya the way they treated Nnamdi Kanu outside the country was illegal. Says that instead of doing that, the judge suggested that they should, find a way to explore alternate political solution in resolving the issues of his extradition, detention, and trial. And we know that for the fact that the president also said at a point in time that he respects the judiciary and that political solution may be possible as well too. The lead counsel, the special counsel to Nnamdi Kanu, which is Aloy Ejimako, actually said that yes, that he would advise President Muhammadu Buhari to also remember his promise to respect the judiciary and do as said.